Okay, good morning, everyone. What I would like to start with is again what I showed you yesterday. So I explained to you what the outset of the problem is, and we've discussed yesterday one specific technique. I talked yesterday morning about collective redress, about representative actions, about class actions, and then in the afternoon I spoke about a variation of public enforcement, the piggyback technique, the partie civile technique. What I would like to do today is I would like to focus a little bit further, because the title of this panel is Class Actions and Public Policies, and when I hear the word public policies, I of course think about public bodies, governmental bodies. And that second technique, and this is also described in this book, the book that I showed you yesterday, and at the end of the conference that I will give to the chair of this panel for the library of this school. We've discussed this technique very extensively in this book. But first of all, very quickly, and it really, it doesn't really has to do in the strict sense with the title of this panel, but I would like to mention it to make my story complete. Because yesterday I explained to you that in Europe, we more and more, not only on the European level, but also on the level of the various member states, more and more attention is being paid to class actions. But I also explained to you, and I showed to you some numbers, is that these instruments are not very successful. They are not being used a lot. In some countries, we only had a handful of these cases. And then the question arises is, why is that? And the reason is, first of all, it has something to do with what I explained to you yesterday, in the sense that a lot of these instruments have too many safeguards. And if you create a procedural instrument, a procedural vehicle with too many safeguards, then you create a catch-22 situation. This is the first thing. The second thing is as a consequence of the policy of the European legislature, but also in various member states, attention is also being paid to other techniques. And what is very important to realize is these two other techniques, and I will very briefly mention consumer dispute resolution, because this is a little bit outside of the scope of this conference, but a regulatory redress for this panel is important, is that these techniques basically were created by the market. They were created by companies, they were created by consumer associations, they were created by regulators, by public bodies. Why? Because the class action instrument does not work. I think in Brazil, for example, courts have a lot of cases to deal with. I heard some numbers yesterday. It's really a lot of cases. For European courts, it's exactly the same. Going to court costs a lot of money. It takes a lot of time. In some countries, going to court is extremely expensive. For example, in the UK, going to court costs you a fortune. In other countries, it will take you years. For example, in Spain and in Italy, the backlog there is enormous. So because there is this problem with going to courts, other instruments, other techniques were developed, and I would like to focus on this very quickly. First of all, consumer dispute resolution. I will just very briefly mention what this is. I have a lot of slides on this, but I will not show everything because it would take me too far. I think most of you are familiar with alternative dispute resolution. Yesterday, somebody, I remember, asked a question about arbitration. There is mediation, there is negotiation, there is conciliation. And as the judge yesterday in the last panel also mentioned, he also said that in Brazilian courts he has noticed over the course of the years that more and more parties try to settle cases outside of the courts via via mediation. Now, we have that also in Europe. There are some European instruments that are dealing with that. But what is different than traditional ADR is what we call consumer dispute resolution. Consumer dispute resolution is the use of alternative dispute resolution, is the use of mediation, negotiation, arbitration, and conciliation, but within a framework that is completely different than courts. And the main tool or the main forum where this is used is via the use of ombudsman. I think you have ombudsman in Brazil. Do you have public ombudsman, private ombudsman? I don't know, but now I am talking about private ombudsman. And this goes back to a regulation, to a directive. This is the one. In 2013, and remember yesterday I spoke about the recommendation on injunctive and compensatory collective redress that also dates from 2013, and this instrument also dates from 2013. So for the policymakers, this class action instrument on the one hand and consumer dispute resolution on the other hand, they go hand in hand. And this directive basically states the following. The directive says in all of the European countries, the policymakers, the legislator, has to create a mechanism for consumers to be able to be used to settle their consumer disputes outside of court. So that directive obliges all the member states to have an ADR entity that deals with consumer disputes, to have ombudsman. And in the meanwhile, this directive has been implemented in all of the member states, and it's extremely successful. It's extremely successful. For example, in Belgium now, almost all minor consumer disputes don't go to court anymore, but are being resolved by, we now have what is called a consumer mediation service. And that consumer mediation service is an ombudsman and uses the technique of mediation to resolve the disputes. And most of these ADR entities, and in some countries they work extremely well. For example, in the UK, you have the Financial Ombudsman Service, which deals with disputes you have as a consumer with banks, with insurance companies. All of these disputes are being dealt with by the FOS. In total, I think that Financial Ombudsman Service has, I think, almost 4,000 people who are working for them. I think they are dealing with hundreds of thousands of complaints every year. So all of these consumer disputes don't go through the court anymore, but go via these ombudsmen. And most of them work via this technique, as you can see on the slide. First of all, of course, if you have a problem as a consumer with a trader, then of course you have to contact the trader first of all and say, look, I bought this product is deficient, how are we going to resolve this? If that doesn't work, then there is a referral to a third party, an ADR entity, and then that ADR entity will first try and resolve the dispute via mediation or conciliation. If that doesn't work, then there will be adjudication, usually arbitration. So this is the method how most of these consumer disputes are being dealt with. There are different models, but I will not go into the details. This is the example of Belgium, if I can, whoops, okay. So in Belgium, we have, on the left-hand corner, you see Consumentenombudsdienst. This is this consumer mediation service. But what we also have, and you see there, this is called Belnet, is all of these disputes are being dealt with online. So I will explain to you how this works. It's very simple. So we have in Belgium, we have a lot of ombudsmen. Okay, there's an ombudsman, for example, for banks. There's an ombudsman for insurances. There's an ombudsman for postal services. There's one for railway services. There is one, if you have for SMEs. There's one for if you have a travel dispute. In all the different sectors, there's a specific ombudsman. if you have a problem in a sector that does not have an ombudsman, then the consumer mediation service will take care of that. They are what is called the residual ADR entity. You as a consumer does not have to find out, okay, do I have to go to this ombudsman, or this ombudsman? No. What you do is you go to the website of that Belmet, which is something that is offered by the government, by the Minister of Consumer Affairs. You go online. It is available in 4 languages, in Dutch, in French, in German, and in English. You fill out the form, you fill out your name, you fill out the name of the company you have a problem with, you fill out, you explain what the problem is, you can attach documents online, okay, and then you click on send. And then the system will automatically recognize, okay, this is a problem that will be dealt with by the Ombudsman for Energy. And then the system automatically sends the dossier to the Ombudsman for Energy that will contact you, okay? It's for free. You do not have to pay for this. This is completely for free. And it goes very quickly. The residual one, I'm showing you some numbers of the residual one. Most of these complaints are being dealt with in a time frame usually of 25 to 30 days. They're being dealt with. And in most of the cases, as you can see, in more than 50% of the cases, there is a settlement. So all of these consumer disputes are not being dealt with by the courts, are not being dealt with by collective actions, by class actions, but are being dealt with outside of the courts. I could say a lot about this, but I just want to mention this technique, and I don't know if this exists, something similar exists in Brazil. What is more important is and this is the second technique, and this is more relevant for this panel, which deals with public policies, which deals with regulatory redress. I think I already mentioned yesterday that if a company, a trader, or a government agency, whatever, does something wrong, then there will be an investigation by a regulator, by a public body. For example, you have an environmental disaster. Okay, what will happen is there will be a public process. There will be a government agency, a regulator that will do an investigation to find out if a company violated the law, yes or no. You have a company that puts a drug on the market. There's a problem with that drug. People get sick, okay? There's a regulator that will do an investigation if something goes wrong. What that regulator does, and this is something new. Again, this is not, what I'm now talking about is not something that is the result of a specific policy. What I will now speak about is something that has been developed by the market, between brackets, because going to court does not work. What you see in a lot of countries is, and this is what is happening, or what exists in most countries, you have the regulator that does an investigation, and if a company did something wrong, then the regulator will impose a fine on the company. The company will have to pay a fine because they did something wrong. For example, in competition law, what they do, if a company violates rules of competition law, they have to pay a fine. And what is the fine? The fine is a certain percentage of the revenue of the company over a number of years, and they have to pay this fine. Okay. Then this public process finishes, and as I explained yesterday, then in a second phase, you can have a private process. Then you can have people who suffered damages, who will sue that company before the court individually or collectively via a class action to claim compensation. So you have two different procedures. You have a public procedure in which you have a regulator imposing a fine on the company, and a second phase in which you have victims who suffered damages, who suffered harm, that will sue the company to claim compensation. Okay, these are two different processes. Regulatory redress basically merges these two processes and allows for regulators not only to punish the company with a fine, but at the same time force companies or government agencies, if a government agency did something wrong, to pay back the people who suffered harm. That is the technique of regulatory redress. So the regulator there acts as the regulator acts as the institution that will force the company to pay back the harm that people have suffered. And here you can see an example of what is traditionally known. If, for example, regulators hit banks with big penalties. If, for example, there was, and these are examples, I think, from the UK, where in the UK you had a lot of cases with banks that were violating consumer law rules, that were violating competition law rules. There were a lot of investigators, and they were hit. This is what they traditionally do, is they have to pay fines. This is what a regulator does. But, and I will mainly speak about the UK, because this technique, there's only one country in the UK, there's only one country, jurisdiction in Europe, where this technique has, after a number of years, has been, they laid it down in a law. I will come back to that in a second. It's called the Regulatory Enforcement and Sanctions Act of 2008. So that regulatory redress, and here you can see a definition, is redress that is ordered or brought about by the intervention of public enforcers, and it is a combination of public regulatory enforcement and civil compensatory enforcement. This is something very controversial. This is basically something we found out by accident in this book. We were talking to a number of people in a number of countries, and we were asking the question, how do you resolve these collective problems? Do you have class actions? Do you use these class actions? And in a number of countries they said, no, we don't have class actions, but we use this technique. I will come back to the downsides, to the possible, the problems in a second, but I will first give you some examples to make this clear. And on the slide, you can see some examples that we found out and that we describe in the book. For example, in Italy. In Italy you have banks, and the regulator in Italy is the Banca d'Italia. And the Banca d'Italia is a government agency, it's a public body, it's the public regulator that controls if the banks are following the rules, are following consumer law rules, are following the rules on competition law, etc. If a bank, the Banca d'Italia, the regulator in Italy, finds out that a company, that a bank or an insurance company violated the law, then the regulator can issue what are called specifiche forme d'offerta, which is an order to redress. They can force the banks to pay back the people who have suffered harm. Over a number of years, I think they were able to recuperate almost 60 million euros via this technique. So the people who were the victim of that, they don't have to do anything. They don't have to go to court, they don't have to file a complaint. It is the regulator that orders the bank to pay back people. Another example, Deutsche Bahn. I don't know if you know Deutsche Bahn. Deutsche Bahn is a German company, and Deutsche Bahn owns all the railroads in Germany. So the railroads that are being used by the trains, they own all the railroads in Germany. Deutsche Bahn allows other companies to rent their tracks. It's called traction current. So there are other companies that can use the railroads of Deutsche Bahn, and of course these companies have to pay something to Deutsche Bahn because they want to use the railroads. At one point, the European Commission, and the European Commission in Europe acts as a regulator, as an enforcement agency regarding competition law. The European Commission found out that Deutsche Bahn was charging more money to companies that do not belong to Deutsche Bahn, and that companies that belong to Deutsche Bahn got a discount. So it was a violation of competition law rules. And the European Commission started an investigation. What you would think is, okay, the European Commission will start an investigation, and if competition rules are being violated, Deutsche Bahn will be hit by a fine. Deutsche Bahn immediately said, we're very sorry, we did something wrong, we will pay everybody back. And Deutsche Bahn made a plan, they set out a plan, and based on that plan, they voluntarily said, we will pay all the companies back for a number of years, and we will pay them back until the moment that they are completely compensated, that they have full compensation plus an additional compensation. And the European Commission said, okay, let's implement your plan. And after a number of years, Deutsche Bahn paid everybody back, and then the European Commission, as the regulator, had to impose a fine. They imposed the fine, but the fine was €1 symbolic, because Deutsche Bahn voluntarily, under pressure of the regulator, paid everybody back. Volkswagen is exactly the same. Volkswagen now, in all of these European countries, they are setting up plans to pay back everybody voluntarily. Why? Because they want to receive a discount when they will be hit by the regulators. The Danish Consumer Ombudsman, and this is a very nice poster of The Economist of a couple of years ago, and there was an article in The Economist that was describing this technique, and it used the Scandinavian countries as the example. And the journalists of the article said that these Scandinavian countries with that regulatory redress technique are called the next supermodel. The Danish Consumer Ombudsman, but the term is misleading. The Danish Consumer Ombudsman is not a traditional ombudsman, is a regulator, is a government agency, is a public body that deals with consumer law. So if a company violates rules of consumer law, then the Danish Consumer Ombudsman, the regulator, can impose a fine on these companies. What that Danish Consumer Ombudsman also can is that Danish Consumer Ombudsman, a public body, can bring an opt-out class action. In Denmark you have class actions, but you only have opt-in class actions. Only the regulator, the Danish Consumer Ombudsman, is the only entity that can bring an opt-out class action. He already has that tool, now it's a she, it used to be he, now it's a she, already has this tool for a number of years. Today, that Consumer Ombudsman has brought 0 class actions. Why? Because that regulator is using that class action to force the companies to pay back victims voluntarily. The previous Consumer Ombudsman was a man, and he used to call it, I met him at various conferences, he always gave the same talk, and he always spoke about his nuclear bomb. He said to the companies, you will pay everybody back, won't you? Otherwise, I will go to my cellar, I will take my nuclear bomb, and I will throw it at you. And all of the companies were very scared, and they paid back. And it changed, and this is important, because of that policy that he was using, it led to a change in mentality in Denmark. What the companies now do is, okay, they are being confronted with a collective problem. Oh my God, we did something wrong. How are we going to resolve this? What they now do is they voluntarily go to the Danish Consumer Ombudsman, even at a point where the Ombudsman doesn't know there is a problem, and they said, please help us. please help us set up a plan, say it is okay, monitor the plan so that we can pay back everybody. And this is it has led that policy that the consumer ombudsman has used has led to a shift in mentality of Danish businesses. And there are other examples too. The best example you can find in the UK, okay? In the UK, all regulators, all public bodies need to have a specific policy. They need to publish that policy. It has to be known to the public how they will deal with their cases, what their priorities are, how their methodology is, etc. They have to publish this, okay? Many, many years ago, there was a professor in the UK, Richard McCrory, who was given the task to evaluate all of these public policies of these regulators. And McCrory analyzed all of these policies, and he came to the conclusion that the good public policy of a good public regulator should have 6 basic principles. He called them 6 penalty principles. And one of these penalty principles, according to McCrory, is that these regulators, these government bodies, also should pay attention, should focus on compensating people, focus on restitution, which was completely new. McCrory discovered that some of these regulators are doing this, others are not doing this, but he thought that this should be a fundamental principle that should underlie every public policy. These 6 penalty principles of McCrory later were laid down in the Regulatory Enforcement and Sanctions Act, RESA Act of 2008. The Act was later amended, I think, in 2015 by the Consumer Rights Bill, and that Act allows for regulators, it doesn't oblige regulators, but it allows for regulators to have that regulatory redress technique in their toolbox. You always have to think about a carpenter. A carpenter has a toolbox. In the toolbox, there are different instruments, okay? These regulators also have a toolbox, and one of the tools they have in their toolbox is that regulatory redress power. If they have that, they can force companies to pay back. And this is the consequence. What you here see is numbers of Ofgem, which is a regulator in the UK that deals with gas and electricity. And in the light gray, you can see the penalties, the fines they impose. What you see in dark is regulatory redress, voluntary redress, payments to charitable organizations, and direct compensation to consumers. And what you have seen over the number of the years is that the regulator, Ofgem, does not impose fines anymore. What they do is they issue orders in which companies are forced to pay back people voluntarily. And this is the consequence of that redress power. Yeah, it's gas and electricity markets. Now, there's a catch, okay? It sounds very nice, it sounds very good, but there are some problems with this. First of all, we are talking about government agencies, we are talking about public bodies, okay? Who's in charge of these public bodies? The government. And there you have the first main problem is political capture. The government, the competent minister, of course, can steer this. Okay, so there's a danger that there could be abuses, okay, that they do not act for all of the companies in the same way, that there is political capture. This is the first problem. The second problem is that a lot of these regulators, okay, don't have the knowledge and the means to deal with compensation. Yesterday we spoke about the quantification of damages. Somebody was asking a question, if you have a collective problem, how do you quantify these damages? How do you quantify these harms? How do you pay people back? To be able to do that, you need to have some experience. These regulators don't have that experience. Moreover, these regulators, most of these regulators, are being faced with budgetary constraints. Okay, they don't have the money they have at their disposal is limited, okay, they have to set out priorities, and this thing, regulatory redress, is for a lot of these regulators is not a priority. So this is also a problem. There are solutions, and in the book we've listed some of the solutions that could be used in order for regulatory redress to work. A publication of enforcement policies, which is very important, and goes back to that idea of macro. If you have a government agency, then the policy of that government agency should be published in detail. People should know how it works, what their priorities are, what the methodology is, how they function, who works there, if there are potential conflict of interest, etc. So full transparency of that public policy. Fair procedural rules, possibility for courts to impose more serious sanctions, and a mechanism for appeals, judicial review. In the UK, it is possible that if you have a regulator imposing regulatory redress, then the company has always the possibility to go to court and ask for a judicial review, to say, I disagree with this, I think it's unfair, I think it's not equitable, and you always should have that possibility. So this is something that is new, and that is something that is being developed. At one point, it was the object of negotiations on the European level. We have what is called in the European Union, there is a regulation, it is called the CPC regulation. And the CPC regulation is the Consumer Protection Cooperation Regulation. Yesterday, I mentioned that a lot of these collective problems are of a cross-border nature. Okay, you have a specific consumer problem in one country, but the problem is not limited to that one country. It also has a problem in other countries. For example, the Volkswagen case is a problem that occurred in all European jurisdictions. Okay. In all of these European jurisdictions, you will have the regulator, the consumer regulator, that does an investigation, which is kind of stupid, because you have 15 or 20 regulators that are basically doing the same work. The CPC regulation, which is a European instrument, allows the coordination of all of these regulators. For example, a couple of years ago, there was a problem with, I don't know the details, but there was a problem, a consumer problem in Belgium, the Netherlands, and Luxembourg, okay? The regulator in Belgium did an investigation, the regulator in the Netherlands did an investigation, and the regulator in Luxembourg did an investigation. That CPC regulation allows these three regulators to come together and to do the same, so that there is uniformity. Suppose you have something here in South America, there's a problem in Brazil, in Chile, and in Argentina. Okay, that CPC regulation would lead to the fact that these three regulators would work together. Okay. 2 years ago, the CPC regulation, the statutory framework that deals with this, was revised, and there was a proposal in the European Parliament to allow those regulators to use that regulatory redress power. Unfortunately, that amendment was not accepted because of the reasons that I just mentioned, because of the downside effects, the possible disadvantages, the possible dangers this could have. So ultimately, it was not being implemented. So for the moment, it doesn't exist in a lot of countries, but it is something to take into account. And I think with that, I will leave it here. So I don't know, and I would be very interested to find out whether something similar exists in Brazil. So thank you for your attention. If you have any questions, please feel free to ask.